Appeals. We've received your cases in advance, have studied them, and in some cases visited the site. Please understand that we don't bring these cases. We are citizens tasked with weighing the evidence submitted in order to make the most informed decision possible. We have no personal interest or stake in these cases except for the overall good of the community. The staff has made a recommendation on each case, and that recommendation is input only and may not necessarily be the opinion of this board. If you are planning to speak for or against any application, you must be sworn in prior to testifying. If you have not yet been sworn in, please do so now with the clerk at the right front table. This is how we will proceed. When your case is called by staff, the applicant should come right to the podium and give us your name and address. The applicant will then present their case, including comments from any supporters in attendance. Comments by supporters should be new information and not just an expression of support. The applicant may display the volume of support by a show of hands, and speakers will have 3 minutes. Opponents will then be given the opportunity to state their objection. If there are numerous opponents, it's preferable for them to select 1 or 2 spokespersons. Those speakers will also have 3 minutes. Subsequent objectors should add new information and not just rehash prior stated objections. Opponents may also display the volume of objectors by show of hands. This will be the only opportunity for the opponents to state their side. The applicant will then return solely to rebuke comments of any opponents and may not bring any new information or testimony at that time. And then finally, we will close the public hearing and the board will discuss the case, make a motion, and vote. And with that, let me turn it over to Mr. McAteer to provide additional information about our procedures today.
Thank you, Mr. Chair. The matters heard by the Board of Adjustment and Appeals are quasi-judicial in nature. Please note that only competent, substantial, fact-based testimony or evidence may be considered by the board in deciding the matters before it. Pure speculation or opinion, not based on competent facts, cannot be legally considered by the board. Lay testimony with fact-based support, including but not limited to meeting minutes, surveys, engineering reports, etc., may be considered competent and substantial evidence. Thank you.
Okay, and with that, staff, please call our first case.
Hi, good morning. Michael Schoderbach, zoning manager. First case is TY2-24-01. Owner is CMNY Tech Drive LLC with Representative Bruce Vaughn. This is a type 2 use request to allow a fitness center in an E1 zone for the property located at 3051 Tech Drive in unincorporated Pinellas Park. Staff recommends conditional approval. The request is for a fitness center in the southern portion of an existing 2-story office building. The new tenant intends to retrofit approximately 14,915 square feet of the southern half of the existing building as a semi-private training facility for bodybuilders and professional athletes. All operations and equipment would be interior to the building. No new structures will be built. No exterior improvements are proposed or needed. The uses on the other portions of the site would remain unchanged. There's plenty of parking at the site. We've done the calculations based on this use coming in, and again, no exterior improvements proposed or needed. And again, staff recommends conditional approval.
Okay, and is there anyone in opposition in the audience? Okay. Name and address, please.
Good morning, Jeff Claypax with Commercial Partners Realty. I'm representing Derek Lunsford. The address is 3051 Tech Drive, St. Petersburg. Derek was stuck overnight in the LA airport, calling me frantically this morning. His wife was prepared to come from Oldsmar with their 6-month-old, 2 teeth coming in. Bruce is here representing the ownership group as well. We decided that we would be able to take care of it as authorized representatives. Not a whole lot of other, items to speak on. Had a really good DRC meeting last month, and glad to answer any questions or concerns that you guys might have for this group.
So you're appealing to our sympathy over your plight.
No sympathy here. By the way, Derek's 2-time, 2 out of the last 3 years, Mr. Olympia. So he's a kind of a national and even a global figure right now. He's about my height and twice the width.
You shape Mr. Burdett into shape.
We have about 100 questions for you. Ready?
Yeah, I'm
I'm
ready.
start. No.
Thank you.
Seeing no objections, I'm going to move for staff recommendation of conditional approval for the type 2 request based on the findings of fact as outlined in the staff report.
Second.
Okay, we have a motion and a second. All in favor?
Aye.
Aye. That's it.
Thank
Very
you.
well, thank you.
Appreciate it.
Our next case is VAR-24-08, Daryl and Jessica Grimm. This is a variance request for the construction of a pool screen enclosure having a 10-foot setback from the midpoint of a seawall, where 15 feet from the midpoint of a seawall is required in an R3 zone for the property located at 3150 South Canal Drive in Palm Harbor. Recommendation is conditional approval. The subject property is on South Canal Drive in Palm Harbor. It's developed with a single-family home and an in-ground pool that's currently under construction. This is on a property is located on a cul-de-sac, and it backs up to Lake Tarpon. So due to the property being on a cul-de-sac, with the curvature of the roadway on the lot, the existing single-family home is set further back from other abutting single-family homes, which limits the area in the back for construction. So we allow on waterfront lots, if there's no seawall, you have a 25-foot setback. If there's a seawall, there's 15-foot for structures. We allow the pool to encroach if they've provided certification from an engineer that the seawall wouldn't be affected. In this case, they have. So the pool is fine. It's just the request is for the screen enclosure. We also look at this as a way to prevent structures from obstructing the waterfront view from neighboring property owners. This proposed screen enclosure will have minimal impact. We have received letters from the 2 adjacent property owners that are in support of this, and then also the shape of the entire shoreline on the back of the property, not just theirs, but the others, kind of comes in at an angle, so we don't see that there would be any obstruction from view for any neighboring properties. So staff recommends conditional approval.
All right, is there anyone here in opposition? All right, name and address, please.
Daryl Grimm, 3150 South Canal Drive, Palm Harbor, Florida.
All right,
My wife couldn't be here, she had a death in the family, but I did bring a neighbor with me that got the letter as well for support, so.
Just a question. Did your pool permit include the enclosure
Yes, sir.
when you got the permit?
Yes, sir.
And the county issued the permit?
Yes, sir.
Yeah, the screen enclosure is a separate permit from the pool.
Yeah.
So there's 2 separate permits. When it was submitted for the pool permit, the screen enclosure was shown on there. So the pool permit was issued. Subsequent to that, when the screen enclosure came in for permit, that was when it was flagged that needed a variance. Just didn't meet the
We
setback.
should probably address that internally,
Yes. We,
because you get all the way along with the pool and then find out when you go to permit the screen enclosure, you got a problem.
yeah, it was addressed because it was clearly shown on that, and that was missed by staff who was reviewing it.
Okay. Seeing no objections, I want to move for staff recommendation of conditional approval in accordance with the findings of fact as outlined in the staff recommendation.
Second.
all right, we have a motion and a second. All in favor?
Aye.
All right, thank you. Congrats.
Our next case is VAR 2409 from John Schaefer, the applicant. This is a variance to allow for the conversion of approximately 353 square feet of a covered, unenclosed porch into an enclosed conditioned space for a kitchen, having a 12-foot front setback from the northern property line where 20 feet is required, for the property located at 1342 Michigan Avenue in Palm Harbor. Staff recommends conditional approval. This is a corner lot where Michigan Avenue is the primary front and 14th Street is a side street. So the subject property previously received a variance for the construction of a porch addition in 2014 to allow an 11-foot front setback from the property line adjacent to Michigan Avenue where 20 feet is required. So the applicant intends to enclose 353 square feet of this existing unenclosed covered porch area to relocate their kitchen. No additional structures or exterior improvements are being proposed by the applicant that would increase the footprint of the existing single-family residence. the proposed renovation will occur under the existing roof line. So it's staff's opinion that the proposed renovations will make the existing single-family residence more functional and will not effectively alter the neighborhood. Additionally, there's environmental features, there's plant material, landscaping on the site that helps to buffer this area so it's well screened from nearby properties. And one of our condition is that they would maintain this landscaping to provide that buffering. Just for the record, just again, staff's recommending conditional approval, but during the Development Review Committee meeting, there were a couple of staff expressed some concerns. The DRS Engineering Division expressed concerns that a new addition could be built to accommodate the expansion that meets all building setbacks. And Public Works noted that the prior BAA decision for the porch included a condition that the porch remain open. In addition, they would recommend that the setback request be adjusted back to match the current building enclosed frontage, keeping in line with the house.
All right. Anyone in opposition in the audience? All right. Name and address,
Hi.
please.
My name is Marioli Schaefer. My husband, John Schaefer, can be here because he's a merchant marine, so he's sailing as we speak. I live in 1342 Michigan Avenue in Palm Harbor. And as he explained, all we wanted to do was to enclose the existing porch to accommodate space for a kitchen.
So, Michael, question. So you had some concerns, some of the DRS folks had concerns, but they still recommended approval in the end?
Yeah.
You twisted their arms?
Yes, we did.
You know, Chelsea wouldn't have gone along with this one, but different era.
All right.
Are there any objectors?
There are not.
Objectors? I'm gonna make a motion to recommend staff recommendation of conditional approval in accordance with the findings of fact as outlined in the staff recommendation.
Second.
All right. We have a motion and a second. All in favor?
Aye.
Aye. All right. Congratulations. That's it.
Thank you.
All right. We have, need a motion for,
Hey, we got one more case.
oh, I'm sorry.
And let's do them all.
Sorry,
We'll do them all
I'm
today.
on a roll. Long day ahead. All right, let's
we're
get
not
after
done
it.
Easy ones, now.
Yeah.
Our next case is VAR-24-11.
Right.
Owner is Joel Kazowitz. This is a request for variance to the dock length requirements in unincorporated areas under County Code Section 58-555, subsection B, subsection 1. We have staff from Water and Navigation is here. They can provide additional information and background on this case as well and do presentation.
They want to go first.
Yeah, well, the Water and
Staff
Nav
go
staff
first.
do first, yeah.
You know the drill.
All right. Okay. Hello, I'm David Brian Brown. I am the Environmental Manager for the Ecological Services, Marine Safety, and Water and Navigation section for Pinellas County Public Works. Today I will be presenting the variance request for VAR-24-11 for Joel Kazowitz, single-family dock. The subject property is located at 780 Columbus Drive in Tierra Verde in unincorporated Pinellas County. As you may recall from past presentations, one of the more interesting requirements of the Water and Nav Code is Section 58555B1. That part of the code reads as follows: private docks to be constructed in waters of the county shall be constructed so that the length of the dock, excluding tide poles, shall not extend from the mean high water line or seawall of the property further than 1/2 the width of the property at the waterfront. This requirement may be waived by the county provided a signed statement of no objection from both adjacent property owners have been submitted. With that as the backdrop, on December 27, 2023, the applicant applied to the Water and Navigation section for authorization to construct a 416-square-foot single-family dock and four-post, 13,000-pound boat lift. This application was subsequently reviewed and issued by staff on January 2nd, 2024. After construction was complete, Water and Nav staff received a complaint from a neighboring property owner over concerns related to the location of the boat lift. In response, staff conducted a final inspection on February 14th, 2024, and discovered that the boat lift did in fact conflict with the criteria outlined in section 58555B1. To address this issue, staff advised and encouraged the applicant to seek letters of no objection from the adjacent property owners. Since our February inspection date, Mr. Kasowitz has been able to obtain the signature from the northern property owner. However, he has not been able to obtain sign-off from the southern property owner. The next 5 slides are a series of photos designed to help illustrate the current condition in and around the site. The first 3 are the actual structure Mr. Kasowitz has built. The 4th slide is a view from the northern property owner, 764 Columbus Drive, looking to the south-southwest, while the 5th and final photo is from the property owner to the south, 788 Columbus Drive, looking to the north-northwest. As you may recall from previous presentations before the board, Section 58539C states that in deciding whether to grant a variance, the Board of Adjustments and Appeals, or the county administrator, or his or her designee shall make a positive finding of fact to all the criteria set forth in Section 138.231 of the Pinellas County Land Development Code. In reviewing those criteria, staff finds no reason other than the nonconformance with Section 58555B1 why the constructed boat lift can't remain in its present location. If you have any questions on how we came to those conclusions, I would refer you to the provided staff report. Therefore, it is our recommendation that you approve the variance pursuant to Section 58555B1 of the Pinellas County Code. A couple additional aspects to consider when making your decisions are as follows. It is important to note that one of the reasons we are here today is because Water and Nav staff made an error in our review of this application. Since becoming aware of this case, my unit manager has gone back to the newer staff to make sure they are properly trained on the implementation and interpretation of sections 58555B1 and 2 to prevent mistakes like this from happening in the future. We have also added a checklist to our newer staff so that they can double check their work before issuance. And the staff member who made the mistake has gone through remedial training and has had a period where senior staff had to review their work before issuance. It is also important to call out that we would not be bringing this matter before you if there were just tie poles at the end of this dock. Historically, mooring did occur at this location, as evident by the tie poles installed in 2002 by a previous property owner of 780 Columbus Drive. And with that, I will open it up for questions.
So you're saying that tie poles would not require an exception to the code?
No. But when somebody adds a boat lift to those, then all of a sudden you would need the signatures.
Is a boat lift is considered structure?
Yes.
And that extends the structure of the dock beyond the allowable limit?
Yes.
The limit being 50% of the width of the lot,
True.
correct?
Yes. So the structure itself that he did construct is perfect. It's within the center third. It only goes out 50 feet, so that the dock itself is fine. It's once you add the boat lift, that 14 feet is what throws it out.
So I know that if you go outside of the center third of the permissible construction area, you would need the sign off of the neighbors on either side. The same thing applies to exceeding the length?
Yes.
How far can you exceed the length? Could you go 40 more feet and get sign offs from the neighbors? What is the criteria?
I believe that if that was the case and he was trying to get out to deeper water because he had a larger boat or a larger vessel in that capacity, sign off would be required. The other side of that, from an environmental standpoint, we would have to look at navigation. Does that 40 feet start to preempt navigation or obstruct navigation, or create a navigational hazard? So sign off would be one thing to approve it and allow it to go forward. Staff would then have to look at it from, all right, well, is this consistent with other docks in the neighborhood, and how far out are they going?
So one of the neighbors, in the packet of letters we received, I think it was the neighbor to the south, was looking for similar sign-off on his desire to add some pilings for his boat, and was unable to achieve it and wound up having to build a new dock. In that neighbor's case, could he have asked for a variance and come before this board to get that variance?
Yes, he could have. He could have. You know, upon exhausting all opportunities to talk to the neighbor and say, would you please sign this? And the neighbor says, no, I'm not going to sign that. He would have had the ability to say, okay, well, then I want to go before the board and request a variance. And I think in his situation, that's what occurred, is that he was looking to just expand his existing boat lift by 2.5 feet. And he, I think, instead of being 33.5 feet away from Mr. Kazowitz's property, he would have only been 31 feet. So he would have still been, you know, and it would have probably, it would have been something that I personally would have supported as manager. I would have said, it's not affecting
Not
Mr.
material.
Kazowitz's navigation, and there's no resource impacts.
Okay.
Anything else?
Hear from
All right, let's bring up Mr.
the applicant.
Kazowitz.
I assume there's objectors in the audience? Is that correct? Yes. Okay.
One.
I'm here on behalf of Bay Docks, the contractor and the applicant in this situation, Mr. Kasowitz. And
And you are?
Your name?
Yeah, your name and address.
Tony
please.
Kuba.
Yeah.
So the first issue I wanted to bring up is that this was built pursuant to an issued permit. The sign-off was not given, but the contractor had a permit given to him by the county. He built it pursuant to the permit. Secondly, the reason why they constructed the dock and the lift on the end of the dock is this is it's past a grill channel. It's a very traveled area. There's a lot of boat wakes, and it's safer to put a smaller boat at this position on the end of the dock to be able to get in and out of the lift. Third, it presents no navigation issues. The dock to the north is 73 feet, so there's no navigation issues. The staff reviewed that. It doesn't impede navigation in any way. Fourth, if they had to move the dock, it would cost a substantial amount of money, $27,000 is the estimate that the contractor gives to move the lift to the other side. Lastly, the only valid objection that a neighbor may have is view. So I want to talk about that for a second. So the view, there's case law, and I'll give you a citation. It's Hayes v. Bowman, and it's 91 Southern 2nd, 795. So Florida Supreme Court case, 1957. Actually arose out of Pinellas County. It's an interesting case. In Boca Ciega Bay, when they were building those fingers that stick out, if you recall, the fingers all have these side streets that stick out. So at the end of one of the side streets, there was a house that had a great view, basically an open bay view. And they were going to extend the finger like this, so it would block his view out to the bay. And the case went up to the Supreme Court. He objected based on view. And it went to the 2nd DCA, which is our district in Pinellas County. And then it went up to the Supreme Court. The Supreme Court said, your view is out the back of your riparian lines. So in this situation, when you look at these docks, the neighbor's view goes straight out. If you notice, one of the pictures that Pinellas County showed was a view on an angle. That's not his riparian protected view. is a riparian protected view. You extend the 2 lines straight out, and that's the view that he has the right to. And it doesn't extend forever. You know, you can build a condo on the other side of that, or you can have a, you know, obstruction on the other end of that view. But it's basically from your riparian lines out to the channel. And that view has been protected there. So based on that, I think a variance is appropriate.
Mr. McAteer, do you agree with that definition of the view rights?
So I was able to pull the case up on Lexus after the citation, and his representation of the case law is correct. So
View is only protected parallel to the lot lines.
with,
If you're on the water, there's a difference as opposed to when we have buildings, but this is, I'm pretty familiar with this one. So.
yeah, so I mean, depending on where you're standing, but yeah, I mean, you have to have a reasonable view of or lack of obstruction, but if it's encroaching within that line, you're standing on the seawall, then that's one issue. If you're standing back, that's another. But generally, yes. I mean, what the case law says, he represented the case law correctly. Is really, I don't want to. I'm trying not to paraphrase a case here, because he did quote the case correctly.
And he is correct, if there are curvatures in the property, or if there's always mitigated circumstances. And I think in Hayes v. Bowman, that case itself, it says that you don't have one bright line rule because there are all different configurations with the property. That was the issue in Hayes. But if, in this case, you got nice square lines, so it makes it a lot easier.
Anyone else?
Has the county offered your client to absorb the cost of the moving of the dock?
No,
I don't think so. Just
but
checking.
we haven't asked.
Okay.
All right, so we hear from the applicant.
That was the applicant.
Very good. Opposition?
Thank you.
Okay, thank you. Name and address.
Hi, thank you guys for your time. My name is John Logan. I am the neighbor directly south of Mr. Joel Kasowitz.
You
Just
just
a little-
stand in the middle there.
Sure, I apologize.
Thank you. No, it's good. Thank you.
The two mics pick you up.
Okay. Just a little background on this. 2 years ago, I went through this exact exercise with the same neighbor. I followed the rules. I asked for his signature because I needed to move my dock, as Mr. Allen had said, 2 feet over to the left. In my own property, just 2 poles, 2 feet to the left. He hung up the phone on me, absolutely no way. I'm not doing anything that affects my view. That was his exact terminology. I didn't bring in an attorney. He brought in an attorney. I'm a normal citizen that's having my own view affected. My rights have been taken from me. No one asked for my permission. No one asked for a signature. They knew this. Joel Kasowitz clearly knew these are the rules. He denied me of it himself. His dock builder, experienced dock builder, many years in this business, clearly knew the rules, yet they submitted a permit. The county accidentally approved it, and now the only one who's actually being affected by this is me. And you can say, hey, it's not that big a deal, it doesn't affect your view. I worked my whole life to earn that view, and now it is being affected because he's putting a pontoon boat 8 feet in the air, sideways, 50 feet off the end of a dock. That wasn't how I purchased my property. The rules are the rules so that I'm able to not have my view obstructed by neighbors. That's what the rules are for. That's why they're put in place. That's why my signature was required.
Is he this guy or
And
this
they're
guy?
trying to steamroll this pass, and the county made a mistake, and now they're asking me, hey, neighbor, you know what, just eat it, because so what, it doesn't really affect your view. But I think if you guys worked your whole life to get that view, and then somebody decided to basically wipe your rights away, the same rights that cost me $120,000, because I wasn't able to move my dock, I had to rebuild it, because he wouldn't let his view be affected. Now my view is affected, and I'm absolutely saying no way, same way he said absolutely no way, because it truly does affect my view. Yes, my property lines are straight. However, I don't know if you guys have ever been to this area. It's a great half-mile long, beautiful area, and you look to the right, you look to the left, and it's beautiful. And to have a pontoon boat sideways, my boat is parallel to the property lines, his is sideways, 15 feet past what is allowed by the county. No one ever asked me at all. Not one word. Still to this day, Joel has never asked me for this permission. Instead, he sends an attorney to give you guys case law to basically wipe away my rights. So I'm here today to ask you to put yourself in my shoes and do what's right.
You had to rebuild your dock, is what your letter said?
I had to rebuild my entire dock because he refused to allow me to move my 2 poles of my dock lift 24 inches in his direction. He said, it won't do anything that'll affect my view, my wife will kill me, and he hung up the phone.
Nobody told you about this board?
No.
How long ago was this?
3 years ago?
Did we have docks 3 years ago?
Yeah. Yeah, it's unfortunate, because you could have come here to get a variance, as staff said, and had another, that's your alternate avenue when you can't get the neighbor to sign off.
Man, I can pretty much tell you that you would have had my vote, but
Well, I appreciate that. Look, I'm a normal citizen. I've never been through this process. I never
Right.
went through the process of building a dock. This obviously is a learning experience. However, these are the rules. I followed the rules because my dock builder
Yeah.
said, these are the rules you have to follow. And so I did that, and look, it cost me a lot of money, and it didn't affect his view. Instead, he's trying to basically affect my view to save himself money.
we hear these, we've heard this argument in county about views, and unfortunately, the case law is correct, and we've heard it and in the past, and we have given variance, but we understand you can't, it's this way, it's just not this way and that way. And fortunately, that's like, as I didn't know it was actually a Supreme Court case on it, but I knew it is the law because we've heard it here on many occasions.
Yes, excuse my voice. This, these instances have come up prior, and I remember one in particular, and I believe Katie Cole was counsel on that, and it also had to do with an obstruction, and was it in Ozona? Or,
It was in
We just give
Ozona.
things in Arizona, that's okay.
I'm sorry?
It was in Ozona, I think.
Yeah.
Ozona.
And that came up again, the obstruction, but if I remember correctly, that this board still went and approved it with that obstruction. And that was what if you remember, it's coming back to me now, Alan, that the gentleman had the bed and breakfast across the street.
Yeah.
And did the maintenance and so on and so forth.
Yeah. Yeah, I really sympathize with Mr. Logan. This is one of those where, karma comes into play here.
Well, right.
Unfortunately, karma is not a usable argument at the board, but you were in the same situation that Mr. Kasowitz was. He told you to pound sand, and now he's asking you for forgiveness, and you understandably gave him back the same answer he gave you. But he does have the alternate road of appeal, which is to come here, and we have to hear the case on the merits of the case itself, not on the prior action that happened. I'm with you, I get it, but unfortunately, it's really not, it doesn't come into play on our decision.
Can I ask a question? Sure. What, I guess, is the rule then for you're not allowed to have it past the 50 feet if basically you just can do it anyways, and you're saying that the view isn't the issue, okay? But, I mean, and I fully understand your positions.
But
You
there are a
guys-
number of cases, each case is different. Each case stands on its own. Sometimes there's seagrass that you have to navigate beyond, and there's shallowness of the water. There are other things that we can look at as far as extending docks or things, so.
Well, that's exactly why I asked the staff the question, how far can you go? How much liberty do we have here as a board to grant a variance, suppose he wanted to go out another 100 feet, and the neighbors said, yeah, that's okay. Do we really have that kind of authority? And that was the point of my question. In this case, it's 14 feet. Is it material? It's material, but staff is saying it's not objectionable, so. I was going to let that guy make his motion.
Mr. Duran.
What are we looking at me for?
Because you haven't spoken up.
You live near the
You
water.
look like you're ready to make a motion. Oh.
I was actually going to ask Mr. Schoderback to address that last question from the staff's point of view. You want to repeat your question? Or do you need it?
I will defer to the water and navigation
Okay,
staff to answer that.
come on down.
The criteria that they look at.
Well, just to
Oh,
reiterate.
by the way, none of this is a criticism of you. I would criticize a whole lot of people who didn't give you the advice that you should have gotten. But having said that, we're here about Mr. Casowitz's case, not yours. We wish we had had the opportunity to address your case, but we didn't until now. I totally understand where you're coming from, and I appreciate karma. Sometimes it doesn't work.
Totally understand. I guess I want to reiterate the point that this was all from a mistake that the county made, right? That allowed this to happen in the first place because my signature was required, and instead, I've been living with this doc for 6 months, and no one's ever given.
Let me correct you there too. Your signature is not required. If you had done it, had signed it, everybody had signed, then you wouldn't be here. The state of, that is not a requirement law. It just gives you a way out to get it done easier. So we don't really have to look at that. We've had cases before where one of the neighbors did not sign off, and we've done various things. But I just want to be clear on that.
Can you repeat the question for me?
That was John's question.
Mr. Logan?
Yeah.
Could you repeat
just
the
repeat
question?
that last question?
So I just, if the rules are it can only be 50 feet, why do you just allow it then to be past 50 feet? Why doesn't everyone just ask for it past 50 feet? Obviously, there was a reason, and it can't be just navigation. It
So
has
the
to
short
be-
version is, why do you recommend that it be okay beyond 50 feet?
So,
Bullet points, please.
yeah, so
They made a mistake.
to what Mr. Burdette had said, if there are extenuating circumstances, shallow water, seagrasses, if there's a reasonable,
This case
but
specific.
for this case, so as it stands for this case, when I talk to my staff and I tell them what I want their focus to be, it's always for the avoidance and minimization to resources and impacts. From there, it's focusing on navigation, making sure I'm not obstructing, that we're not obstructing any navigation, we're not creating any navigational hazards. The third aspect that I would tell them to focus on is there anything about the project that would improve the overall quality of the environment? And in this case, boat lifts do that because they get vessels out of the water. So it's a net improvement to water quality for anybody who wants to install a boat lift to get it out of the water. So that's why I would approve this and support this, is because of what the action is doing. You know, if it's the board's decision that it can't remain or whatnot, he would have to, if we couldn't come to a solution, have to move it around. He could move the lift and the boat would still be in Mr. Logan's view. So, you know, I mean,
Yeah.
again, that's an option before the board that they can make.
And Mr. Chair, I think maybe what the question is, we do have criteria for the variance that are addressed by staff. The board gets to weigh the arguments of staff against what they hear in the hearing and everything else. But there is, A is special conditions, and I won't restate it, but it's in there. And I think that may be what I heard the question to be. What are the special conditions for the situation? Staff has a paragraph in there, in the staff report about special conditions.
And
So it's
in
up to
that-
the board to weigh it, how much weight you want to give it, but.
Let me rephrase it. If someone wants to build beyond 50 feet, we don't just willy-nilly approve it.
No, there are criteria under 138, 231. that you have to
It's not
consider.
50 feet, it's half the,
But that's the willy-nilly rule. I'm sorry, I can't help it. There is no such.
That's why we
rule.
have,
There's a 50-foot rule, yes, but
yeah.
we, as
You
a
guys
board, can
exist,
approve beyond 50 feet on a 100-foot lot if the criteria are met, not just because somebody asked for it. That's my point. Should have said that in the first place.
Here, it's here.
Right, got it.
Thank you.
Thank you, sir.
All right, thank you.
Just 2 seconds.
Yeah.
So I know.
Yep.
To your exact point, what are the circumstances besides, whoops, the county made a mistake that make this okay? That there's no obstruction of seagrass or things like that? There's nothing other than it's now a convenience to just keep it that way, but it's an inconvenience to me that I should have had a say in.
Okay,
and let me just,
Gotcha. Let it go.
just, he can just put it on the side and it'd be the same situation.
And that's all I'm asking. Put it on the side, but don't put it at the end, it's 15 feet, and then put it sideways with a big ugly pontoon with a canopy. I mean, that's really offensive to do to this level of property when every other boat is to the side of their dock like mine.
Okay, thanks, man.
Gotcha.
I understand that, but let me say this for the record. We're not, if we approve this, we're not approving it because the county made a mistake. If we approve this, we're approving it because he meets the criteria for the variance requested. And one of those is the special conditions, and they've given us a long list of special conditions. I'll read them to you if you want me to.
Can you please?
Yes. This area of the county has very strong currents, higher than normal winds, along with a high amount of boat traffic, which results in larger waves. All these factors can lead to a uniquely difficult situation when loading and unloading a boat on a boat lift. The additional 14 feet for the boat lift to be located at the end of the dock parallel to the shoreline will help the owner make reasonable use of the dock to access navigable waters safely. Buttressing these length constraints, the north neighbor's dock is also approximately the same length. That's the special conditions. There's a whole list of criteria, and the staff has concluded that all the criteria have been met. Correct, Mr. Schotterbeck?
That's correct, yes.
Yes. So there you are.
Because it's rough waters, that having it sideways is better, to take waves directly to the side of the boat while docking. That's on record, what Pinellas County's doing to cover up their mistake. That's now officially okay. You know, as a citizen, there's also avenues I can take that you guys are gonna force me to take when Pinellas County allows this to happen without anyone asking for my signature. I get, you don't need my signature, but, you know, as a taxpayer, pays heavy taxes here, this is really offensive. And to say that having it docked sideways because of rough current, when no one else on this entire waterway has their boat sideways at the end of their dock, we should all have this thing. It makes 0 sense at all. That is just a cover-up for a mistake the county's made, and they don't want to get sued by the dock builder who's saying, you approved my permit. And I'm the one who's going to eat it, and I'm not going to eat it.
All right,
Do your vote.
Good argument, thank you.
thank you.
Thank you.
Any additional discussion?
Yeah, honestly, I don't, it's rhetorical to ask the staff at this point, but had the staff not made the error and had the applicant come in simply requesting to put his lift at the end of the dock, I doubt it would have gotten approved at staff level. And so I can't help but think that the request for approval is to mitigate the error that was made at staff level. And I'm sorry, I happen to agree with Mr. Logan. The lift could be placed on the side of the dock. And yeah, there's expense in doing so, but, you know, that's part of the game.
Anyone else?
No, I agree with that. I thought about the same thing that Alan just said. You know, I've been thinking about that the whole time and how that would go about. I mean, that would go to legal then, right? To proceed, I guess, depending on what Mr. Logan wants to do as well.
And the fact that all the other docks along the way have lifts on the side, and that's typically, I mean, you know, there are, I'm a boat owner, you drive around, you see boats lifts at the end of docks, but the great preponderance of them are on the side of the dock. I don't see a hardship that requires that lift to be on the end of the dock. That was their desire, it accidentally got permitted, and now we're here to give forgiveness for an accidental permitting event. I don't know. It's a tough case.
I would just make a request, and whichever way the board goes, considering the fact that there is some tension here that might go into a further forum, that when the motion is made, that criteria are set forth as to what the basis for the motion is, and either way.
In other words, we should consult with you on the language of the motion.
Just,
Gotcha.
just so that the basis for the decision is clear, either way.
There you go. All right. Anyone for motion?
What was the county's hardship? The variance affords the owner the ability to load and unload a boat on a boat lift in as safely a manner as possible. Additionally, the north neighbor and other nearby neighbors of Columbus enjoy similar dock and boat lift lengths to that being sought by the owner here. Moreover, as discussed below, the variance presents no material harm. Well, that's my old argument, the do no harm argument, which I'm glad to see you guys are embracing that. But the hardship element is kind of dubious in regard to finding a hardship.
I hear everything my colleague has said and respect him.
However,
However, the rhetorical question about what would the staff have done had we addressed this before the fact is hard to say. In fact, it's impossible to say. But what we have in front of us is the staff's recommendation, including their analysis of all the criteria. And the staff's analysis of all the criteria, in their opinion, as the staff, all the criteria are met. And they've given specific answers to responses to each of the criteria, setting forth what their opinion is and what their recommendation is. And this, it's possible that had this come to us in the normal process before it was approved by the county, by the staff, at the staff level, it's very possible that they might have said the same thing. It's possible they might have said something different. I don't know. All I know is what they're telling me now. And what they're telling me now is that all the criteria are met. Indeed, I respect what you said, seriously. And I respect what Mr. Logan has said, and I certainly sympathize with his position. And there's part of me that definitely understands why he's talking about what he's talking about. Again, I wish that a number of people had given you the right advice or had told you something, people that had told you anything that would have brought you here instead of spending $120,000, which in my opinion probably was not necessary. I suspect that had you come before us and the staff given us the same kind of criteria responses that they've given us now, that your request would have been approved. At some point, somebody's going to have to make a motion, and at this point, I suspect it's going to have to be me.
yeah, it's a good intuition.
I can
I've
see that.
always said.
I can see that coming.
Your intuition has always been right on.
Yeah. And we could be here for a long time. Unless somebody else has something to add, I'll try to make a motion.
It's a tough one. I just wish he'd come out. I'm echoing your thing. I wish you'd have come here because this would have been, in my mind, at least for my vote, a very easy thing. You'd have gotten your 2 feet, and because you would have met the criteria. You're not blocking his view by 2 feet. It would have, he's moved straight out. So that was, I'm sorry that your neighbor chose to act that way. It's not good. I just don't like that kind of thing. But that said, I think when people come in and the staff has done their usually great job and are telling us that all the criteria is met, it's just not something that I think I can vote against. Again, I'm really sorry for what happened to you, and it's a shame that people do that to other people. But that's it.
Okay, let's try to make a motion. Based on the staff recommendation, including their analysis of the criteria, which includes a response that satisfies that explains why it satisfies the special conditions criteria, specifically the part about strong currents, safety, and unloading the boat. The criteria about it being there being an unnecessary hardship. The response from the staff is that the variance allows the owner to unload and load the boat safely, which is sort of a reiteration of the other one. And also the north neighbor and other nearby neighbors have boat lifts that are the same length. The criteria about the minimum code deviation being necessary, the staff's response is that you couldn't really change this by zoning, that this is the minimum deviation necessary for the owner to reasonably enjoy and access navigable waters. With respect to the criteria for being consistent with the land development code, the staff's response is that the code sections that applies, 58.555B, is not a part of the land development code, and outside of the variance criteria in the land development code, the variance does not directly implicate any provisions of the land development code. So it's not inconsistent with the land development code. Sorry, we're done.
Say,
Yeah, sorry.
can't.
Not on the record.
Your time is, yeah, thank you.
An additional criteria. An additional criteria is that there have to be consideration of rezoning, and this one is, the response is that rezoning is not appropriate. Not that it couldn't be done, but it wouldn't be appropriate. The criteria for consistency with the comprehensive plan, the variance is consistent with both the future land use chapter as well as the natural resource and coastal management chapters. The criteria that is not detrimental to the public welfare, the only members of the public materially and adversely affected are the south neighbor and the north neighbor. The north neighbor is signed off, the south neighbor is not, and the only theoretical impacts to the neighbors, and as Mr. Logan has said, is access to and view of the navigable waters. The variance does not impede the access of either neighbor, and any view impacts are de minimis, not to Mr. Logan, but in a more specific sense, in a legal context, and certainly do not constitute a detriment to the public welfare. The final criteria is that this is not being done to circumvent board approval, and the response is that the variance doesn't circumvent any previous board approvals. Based on the staff responses to those criteria, to the evidence that's been presented, to the testimony that's been presented by both parties, I recommend approval of the recommendation, staff recommendation.
And you so move.
Oh, and conditions. Just a minute. There are no conditions.
And so that's your motion, sir?
I think so. Was there anything I need to add?
Not to my knowledge.
It probably was a little bit of overkill.
I'll take it.
A little bit, but we got it. We have a motion.
That's the motion, to approve.
We have a motion to approve. Is there a second?
I'll second it.
All right, we have a motion and a second. All in favor?
Aye.
Aye.
All opposed?
Aye.
Aye.
Okay.
All right.
Did you vote?
Yeah, I did. I was opposed.
Okay, so it's
Yeah, we got
4-2 opposed.
4-2. The motion fails.
It was a hell of a try, though. I love the motion.
Thank you.
All right.
I was going to ask you to repeat it, but then
Okay, next.
Right, we got it. So I need a motion to approve minutes from the previous meeting.
We don't have,
so what happened?
So,
was a
to be
motion-
clear, the request has been denied.
Yeah. The request is denied 4-2.
Yeah.
okay.
We need a new motion for denial.
Yeah, that wasn't, we need a motion.
That we have to
Motion
make that. I
failed.
think we have
Motion
to go-
failed.
Go make the other motion. That one.
Need something.
We need a motion,
Deny now?
yes, so
So-
that motion failed. but
I
we-
think we make, we
cases
go
are
back
still
to
open.
Alan's motion.
So the motion fails, we need a motion to deny?
Yes, I think.
Yes, please.
Yes.
With grounds.
How explicit does the motion to deny be?
Ask John to make.
I need grounds.
I'm going to give you, I got it. I'm good. You ready? I'm going to move to deny the staff recommendation on case VAR 2411 based on the lack of a hardship as defined in the criteria, and that the staff's assessment of the hardship is truly not something. A hardship has to be a condition that is not under the control of the applicant, has to be unique to the property, and I can't go along. I don't think that this application meets that criteria, and based on that, I'm going to move to deny the application.
Okay.
We'll second that.
We have a motion to deny and a second. All in favor of denying?
Aye.
Aye. All opposed?
Aye. I mean, I'm with him on this round.
On this run up,
All right, so the motion passes to deny 5-1?
I'm not, then I'm going to go with this one too.
6-0.
6-0 to deny.
Motion to deny,
We'll
6-0.
go to, see,
Are we clear on that?
Well, the clerk, it's the clerk's, you need to ask the clerk that.
Are we good?
May need a roll call vote.
Yeah.
I'm
On the motion
voting
to
for the
deny,
denial.
everybody was a yes.
The motion to deny was made and Mr. Cox second, and then the vote was 6-0 to deny.
Okay, thank you.
You're welcome. All right. Got it. All right. Motion to approve minutes from last meeting.
Move to approve the minutes of June 5th, 2024.
Coming back.
Oh, no, May.
May.
So moved.
Yep, we got a motion and a second. Favor aye.
Aye.
Okay. Thanks.
Aye, cool.
Easy peasy.
Yeah, for you.
I snaked that one.